On this morning's Ag Issues program, a pleasure to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Good to be with you.
As always, a pleasure to have you on to the program. Now, normally we talk about your blog that you keep very updated on things. We're going to talk about a couple of Facebook posts that you put up, though. And this is a long-standing issue that you've probably discussed in detail many, many times. And then, of course, looking at the estate tax and how that looks, or the federal estate tax in this case, and the extent to which it applies to farm and ranch estates. And you really took this in two different parts as far as the numbers specifically, which we'll get to in a second, but you had a part before that as well.
Yeah, I wanted to put some things in perspective because here we go again with the discussion of the, so we've got some groups, we've got senators, we've got legislation that's been proposed entitled, I think Senator Thune entitled it the Death Tax Repeal Act of 2023. Earlier legislation this year in the House along the same lines was also introduced. And repeal has been pitched as saving the family farm. And we've got leaders of various groups that are out there commenting on how necessary this is to save the family farm. And I kind of put that in quotes. Well, let's look at the numbers. And that's all my posts were about. Let's look at the numbers first, and then we can talk policy after that in terms of what would be a good policy with respect to the estate tax. Now, the issue that why they're talking about this in the Congress right now is even though we have a relatively high exemption, it's the highest exemption, the federal estate tax exemption, is the highest point that it's ever been. When I first started out practicing over 30 years ago, it was $600,000. It's now $12.92 million per person. So for a married couple, that's $25.84 million. That's the up to that level. You have no worry about federal estate tax. Now, there are some states that do have an estate tax at death or estate inheritance tax. Iowa has an inheritance tax. Nebraska has an inheritance tax. And there's about 15 other states that have a state estate tax. Now, in those states, none of them have an exemption anywhere near what the federal level is right now. The highest, I believe, is sitting there at about $7 million. But most states are in the $1 to $3 to $5 million range with a rate of about 16 to 20%. The state of Washington has the highest state level estate tax rate of 20% and an exemption that's less than $3 million. So from a state tax standpoint, yeah, there's an issue there, but not in Kansas, not in Missouri, not in Oklahoma, not in Colorado or Wyoming or any of the other states that join us, except for Nebraska. There's that county level inheritance tax that's out there. But that, again, is not on size of the estate. It's a tax on who gets your property. So you can leave it to closely related people and not have to worry about the inheritance tax. And the legislature in Nebraska has started to modify that inheritance tax. So let's keep that in mind. We're working with very high exemption levels. IRS actually publishes the data, Greg, that gives us the exact numbers of how many estates are subject to federal estate tax and how many by state are subject to federal estate tax. And I received a number of comments. I had people try to guess how many estates nationwide and in Kansas were subject to federal estate tax when I made the post. And just about everybody was way off the mark except one. And that one has a farm background and knows his numbers and knows the policy in this. And it's pretty enlightening to most people. And I thought that would be kind of fun to put that one out there, just to have people guess. I don't recall that you participated in it, but now you've got the numbers in front of you, so you know. But many people were way off the mark.
And I would have been, I did not participate, A, but B, I would have been off considerably as far as the numbers are concerned, and I do indeed have those numbers in front of me, and this is for the year 2021. And just enlighten people in that aspect of what was actually done. As you mentioned, these numbers are from the IRS as far as those numbers are concerned. And let's just break it down first for Kansas as perspective.
Yeah, in terms of the taxable federal estate tax returns filed in 2021 for deaths that year in Kansas. Now, I say 2021 because that's the most recent year for which IRS has released the complete data. 22 should be out pretty soon. Usually it's late April, May by the time they get out the previous year's deaths. So 22 should be coming shortly. It's not going to be much different. In fact, it may actually be lower because the exemption jumped by over $800,000 from 21 to 22 and 22 to 23. So it continues to go up. But in 2021, the Kansas federal estate tax, taxable estate tax returns were 19, total of 19. Now, of those, the IRS also breaks it down in terms of what was the decedent's occupation at the time they died. And we don't have, if they have one or fewer, they just kind of put a letter there saying, D, we're not going to disclose this because if we disclose this, we can identify, you can figure out who the estate was if there's only one. It's unknown in Kansas. I think it's likely to be 1 to 3 that were actually taxable, that were farm and ranch estates. Now, the total taxable returns in Kansas, I believe, is 42. But out of that, you have to file. You might have a filing obligation, but no tax. So 42 were filed, 19 showed tax, and out of the 19, there were probably 1 to 3 that involved farm and ranch estates. If we look at some of the other states around us, if we look at Arkansas, for example, there were 22 returns that were filed, and there is a D next to that one. So that tells me that it's one that had a taxable estate. Iowa, 45 and 20. So 45 returns filed, 20 that were taxable, and out of that 20, you would have a subset, again, probably in the 2 to 3 range that involved farm estates. Kansas was 42, and let's see, 42 and 19. It's kind of hard to read the chart. Wyoming, 18 total, and taxable, they put a D, so that tells me it's 1. Now, Nebraska, a little bit different in Nebraska, 45 taxable in Nebraska with 18 that had an estate tax obligation. Now, the reason I say it's different in Nebraska is they also show you the amount. The IRS shows you the amount of tax. So this is in thousands of dollars. So in Nebraska, the tax revenue was $314,683. Multiply that by 1,000. In Kansas, it was $107,629. So the amount of tax paid by the 19 estates in Kansas was about a third of the tax that was paid by the 18 estates in Nebraska. Isn't that interesting?
It's interesting as well that if you look at the ones who had the most, as far as the numbers, it really somewhat breaks down in at least the top. Well, the 4 that were in triple-digit numbers were 4 of the most populous states too.
Yeah, California had the most, and that was 1,156 estate tax returns filed. Florida had 830, and I may not take these in order. New York was 557. Texas was 403. Those are going to be your top ones. And but there's a whole bunch that most of the states are less than 100 federal estate tax returns filed. Now, out of those, in California, for example, 1,156 returns filed, and 519 paid tax. So less than half of those had an estate tax liability, but still had to file. Now, you file, and then you offset it with exemption, and it may wipe out the tax. So there's a filing there's a difference between filing obligation and estate tax that has to be paid. So out of California, in the entire state of California, there are only 519 federal estate tax returns that were filed that had an estate tax obligation. Out of the 519, again, a subset of those would apply to farms and ranches, but it would be a very small subset.
And the total number in 2021, as was mentioned, in just a rough percentage, about 43%, would it had to have paid a state tax of the 6,158 total that were filed as far as the state tax returns?
Yeah, I'm trying to do the math in my head, but there's 6,158 total that had to be filed. Out of that, 2,584 had to pay tax. So I think that's probably about right. Okay. But that's 2,584 total. Of the 6,158 nationally, 263 involved ag estates. And of the 263, those are ones that had filing obligations. A subset of those, again, would be the farm and ranch estates, the number of farm and ranch estates that had to actually pay tax. So some subset of 263 that had a tax filing obligation. That's nationwide for farms and ranches.
And the other part I found interesting was the percentage of the taxable returns with an estate value of less than $20 million. That was nearly, 65%, almost two-thirds of that number.
Yeah, a couple ways to look at that. You've got two-thirds that are $20 million and less, and a third that are more than that. But again, the IRS doesn't give us the breakdown in terms of how many of what I can't tell is how many of those are farm and ranch estates and where they fall. Are they in the third that's above 20 million, or are they in the two-thirds that are below? Now, I sincerely suspect, and we can come close to pulling this information out and figuring it out, I sincerely suspect that the bulk of farm and ranch estates are in the latter category. In other words, they're in the less than $20 million category. That's an important point. I wish we could dig down into the numbers a little bit deeper on that, because that will instruct the policy then. So I think we've debunked the myth that the federal estate tax is necessary to save the family farm. That's not true. Unless you want to take that statement literally, meaning farm singularly, there might be one in Kansas that has an issue, but I know that's not what they're saying. But if we break the numbers down, really, where are the vast majority of farms and ranches at in this country and in Kansas in terms of a taxable estate value? We really need to know that number, which will then instruct the policy as to where the exemption should be set at if we're really concerned about the impact of the tax on farm and ranch estates. Then what we also get into, Greg, is the reason that it doesn't impact farm and ranch estates that much is because as planners we have various tools that we can use to offset the impact of that tax, such as special use valuation, the ability to value that farm and ranch land in the estate at its ag value rather than special use value. And there are all sorts of other techniques that we can do. We can use gifts. We can use minority discounts. So that's why that's been in the issue in recent years, because of administration attempts to try to deny valuation discounts on family-owned businesses. So there are a whole host of other issues that are out there. And again, it's a policy debate as to whether you should have to go through those mechanics to reduce estate tax. But on the other side, going through those mechanics forces people to get into a groove and think about what they need to do from a succession planning standpoint to keep the farm and the ranch in the family. And so it forces people to do planning, and that's good in that respect. But that's separate from the policy issue as to what the tax should be and whether there should be an inheritance tax or an estate tax in the first place. I want to separate those issues out. When you take a look at the numbers, separate that out then from the actual policy.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us. And, well, we talked about your blog earlier, Roger, that a lot of times some of the things you post on there, but this one, talks about common law marriage. And this is one that I'm sure people know, some who might be in a common law marriage itself. But there's a lot of little things that people need to know if you are in a common law marriage, specifically what it takes to be in a common law marriage, but why it matters as well.
Well, it can make a big difference, and I think there may be people out there that think they're in a common law marriage and they're really not under Kansas law, because it takes more than just living together for a certain amount of time. There are actually 3 requirements in Kansas. You have to have the capacity to marry, and that's usually not a problem. The parties have to mutually agree to be presently married. That can be a problem. And they have to hold themselves out mutually to the public as husband and wife. And there have been 3 cases on this, Greg, in the past decade in Kansas. One about 10 or 11 years ago, and then 2 in the past couple of weeks. So this is an issue that comes up, and probably more often than people think. In the case a decade ago, that involved a multi-million-dollar farm estate, and the issue was whether there were spousal inheritance rights with respect to the farm. And this thing went all the way through the court system in Kansas, state and federal. And the reason it gets into federal court is because IRS has its views on this too. And so if you're claiming any type of tax benefit or exemption from federal tax as a spouse, then you got to satisfy the IRS. So it's in their view, I'll tell you, it's more than just living together for a certain amount of time. And they're not going to believe what a lower court in Kansas says. They don't care what any county district court says in Kansas or what the Kansas Court of Appeals says. You could get a favorable opinion by the Kansas Court of Appeals. IRS doesn't care. They're not going to pay attention to it. You have to then go to the Kansas Supreme Court before the IRS is going to pay attention to it. They'll only listen to the state's highest court. And so, you can end up with a bunch of lawyer fees. You can end up in a hassle all the way through the court system and having to deal with that if you don't have a formalized marriage or just think that living together is enough. The two most recent cases on this in Kansas, again, the Supreme Court case, because they had to go to the Supreme Court, even though the Court of Appeals said it was a common law marriage. IRS was saying, we're not going to pay attention to it, so you got to go to the Supreme Court. And then another case, unexpected death, and the question was, and the individual died intestate without a will, and were there spousal rights? So it can come up in pretty interesting ways for a number of reasons. And I would encourage people to go take a look at, if they're interested in that article that I posted recently.
Roger, does it simply come down to, in so many cases, just the word assumption that, I think, hey, we've been married long enough, we're fine, it's not a problem?
Yeah, I think that's what it is. People have, they've read things, they've talked to other people about this, and it happens probably more often than we think. But there are 3 specific requirements in Kansas, and the IRS has its own view, and we need to pay attention to what those requirements and what the IRS position is.
And emphasis, too, of the fact specific requirements in Kansas could be different in Missouri, could be different in Oklahoma, and so on and so on.
Mm-hmm. That's exactly right. Every state that recognizes common law marriage, and there aren't many, but Kansas is one, Iowa is another one, will either have their requirements in state law in the code, or it'll be by judicial decision. So it'll be in the common law of those states. Other states just simply do not recognize the concept. So a couple of things here. You have to pay attention to where you're at, and does your jurisdiction recognize the concept? And then if you're in a jurisdiction that recognizes the concept, what are the rules? So it is more complex than simply living together.
All right. And again, they can read the piece on your blog on that, plus other items, and Facebook as well. So if they want to follow those or want to get up to date on those, where can they find you on the blog and on the Facebook site?
Well, for many of my blog articles, actually 2 posts, 2 places. They're always on my website, and that's washburnlaw.edu/WALTR. But many of those also are carried by Ag Manager with the Department of Ag Econ over at K-State.
All right, sounds good. Roger, as always, appreciate it. Wide range of topics today, but I appreciate the conversation. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest on the Ag Issues program here on 580 WIBW.